Marco Santori, counsel from Pillsbury, Winthrop, Shaw, Pittman, and Santori maybe someday.
My name is Marco Santori. I'm an attorney with Pillsbury, Winthrop, Shaw, Pittman. We're a global law firm, hundreds of attorneys around the world. We represent quite a few different companies, but today I want to talk to you about just a short segment of those companies, which is digital currency companies. Pillsbury Winthrop is one of the leading firms in this space, and to give you a sense of scale, we have counted among our clients probably almost 100 different digital currency companies at this point. So this isn't just a couple of guys in their garage anymore. This is a very big deal in a lot of ways. In addition to Pillsbury Winthrop, I am global policy counsel to a company called blockchain.info. We're the world's largest consumer wallet service, software provider. And I also chair the Bitcoin Foundation's Regulatory Affairs Committee. So I had a script, but I understand we're short on time. So I think at this point, you've gotten a lot of information about what Bitcoin is and what it does and what it might do one day. What I'd like to help do today is try to distill that into a path forward. Now we have all this information, what are some of the things we might do with that information from a legislative standpoint, from a regulatory standpoint? You may have heard one thing about how digital currency companies are regulated. It's critical to understand that right now digital currency companies are among the most heavily regulated companies in America. Digital currency companies on the federal level are regulated by the Bank Secrecy Act and the Patriot Act and various other implementing regulations that FinCEN, a bureau of the Department of the Treasury, the Financial Crimes Enforcement Network, administers. The treatment on the federal level for for digital currency companies that are engaging in money services, like money transmission, like the exchange, one of the exchanges you heard from today, are subject to FinCEN oversight. Now, there's still an ongoing question as to what other oversight they're subject to on the federal level. We may see CFTC regulating people, as we saw with Terra Exchange, who are using Bitcoin or digital currency derivatives. We may see SEC regulate companies in the space who are using Bitcoins as securities. Remember, as we were talking about, attaching a security to a Bitcoin, or possibly even Bitcoin companies raising money by issuing digital tokens. This may one day come under SEC oversight. It isn't today, but it might. But that's actually relatively certain as opposed to what's happening on the state level. And that's probably what I think might be most worthwhile use of the time here today, is talking about how digital currencies are regulated on the state level. I want to say right now that I believe that the task before any state regulator or legislator is, as it is with any new technology with risks and benefits, is maximizing the risks and minimizing and mitigating, maximizing the benefits and minimizing and mitigating the risks. And digital currency entrepreneurs, by the same token, are on the hunt for a jurisdiction that will do this because of what they've experienced under FinCEN oversight, because of what they're experiencing on the state level right now. So states have taken three different approaches to regulating digital currencies. The first approach, so far by the numbers, the most popular approach, is by publishing a formal interpretation, given the regulators will publish guidance on how their existing laws apply to digital currencies. Some states that have taken that tack are Texas and Kansas. This approach has generally been lauded by the digital currency community, although there have been some detractors. And it has the benefit of having a very low legislative footprint. It doesn't require passing any new laws or anything like that. At the same time, it suffers from a round peg, square hole problem. Existing money services laws just were not meant to regulate digital currencies. That much should be true. New Jersey's Money Transmitter Act, for example, was enacted in 1998, and it was intended to apply to money that was held in and sent by banks. Bitcoin, that's just not how it works. That's just not how it works. It's usually individuals that are holding and sending money on their own behalf, or sometimes there are custodial entities that will take custody of Bitcoins and send them on other people's behalf. But none of these implementations were considered when the drafters first put together these rules. I think Bitcoin didn't exist in 1998. It was just invented a few years ago. So here in New Jersey, to be specific, the money transmission law doesn't actually define money transmission. it says a check. It defines some instruments as check, money orders, payment instruments. It doesn't even define money as something that Bitcoin might fall under. In fact, money is specifically defined as a medium of exchange authorized and adopted by the U.S. or a foreign government. I think that for this reason, trying to fit digital currencies into an existing regime might not be the most effective approach. There's another approach. This is what we've seen in New York. And that's to create a new suite of regulations tailored to digital currencies. This is the BitLicense proposal. And this strategy has an enormous benefit because you avoid this round peg, square hole problem. You say, look, this is what the digital currency is today. This is how we want to regulate it. And you gather a bunch of experienced, intelligent people in the room. They tell you what digital currency is. They tell you what their predictions for what digital currency will be in the future. And based on that, you write a law, or you propose a regulation, and you promulgate that regulation or pass that law. But this also has its risks. It's technology-specific regulation. And technology-specific regulation always has its risks, and these are temporal risks primarily. In order for a technology-specific regulation to work, it contemplates and expects that innovation be frozen in the moment in time that the law was written, or at least builds in some flexibility to build in all of the developments that a legislator or a regulator might predict will occur in the near future. You might already understand where I'm getting at. This is just a nightmare with digital currencies. If you would have asked me a year ago, what do Bitcoin businesses do? I would have told you one thing. I would have said they're exchanges. They convert dollars into Bitcoins and vice versa. If you ask me today, what do Bitcoin companies do? Well, gosh, it's not even just exchanging. It's not even just currencies. These companies act as payment processors. They act as media of exchange for things that aren't currency. Things like smart contracts, chain of title products, businesses that a year ago we would have never thought you could implement this stuff. There's just no way. And so you look at today, what we knew a year ago, it only makes your mind boggle as to what you might think you can expect a year from now. This industry is too young for technology-specific regulation. We may find ourselves legislating now to pen in and require licensure from companies that exist as they do today, and find in a year that everything we thought was right was wrong. And that's always a concern whenever you pass regulation. But when you're dealing with an industry that's moving as quickly as this one, I think it's not the most effective way. So there's a third way. This is the final way. This is the final way that states have addressed this problem. And that's by taking a wait-and-see approach. And I got to say, in my mind, there's merit to that approach. If creating a new licensing regime from scratch might end up being short-sighted, if trying to fit in digital currency companies to existing regulation might not be effective, maybe it makes sense to wait and see. Wait and see how digital currencies evolve. Monitor the industry to determine which risks disappear, which risks persist, and then act only when you are reasonably certain that the industry is going to be this way for some time and that your actions are going to be effective. But, as you might guess, I don't think that's the ideal approach either. It has a few problems with it. One, while policymakers wait, consumers are left without protections against the risk of fraud, negligence, and just plain risky and reckless business practices. There are some good reasons to hold the custodians of our money to a higher standard than other businesses. The second problem, while policymakers wait, so do innovators, so do investors, so do prospective customers. Regulatory uncertainty is the most effective method of slowing growth of a new and groundbreaking industry today. The third and related problem is that while policymakers and regulators wait, the state is missing out on all the benefits that come along with being a home to digital currency companies. Last year, over $400 million was invested in digital currency companies. The year before that, less than $100 million. This month, over $100 million. If you do the math, you're seeing exponential, explosive growth in this industry. That is a lot of money. That is a lot of money that could be, that is right now, that could be spent creating New Jersey jobs, leasing New Jersey office space, renting New Jersey apartments, buying meals from New Jersey restaurants and paying New Jersey taxes. But instead, right now, all that money is being spent in California and in New York. Unless New Jersey develops this new digital economy in its own state, it'll watch as that money gets spent in other states and even other countries. So for this reason, I'll close by suggesting an alternative approach. And that's one that contributes to an atmosphere of regulatory certainty and balances the potential for economic progress against the need for consumer protections. It means considering new legislation that incentivizes digital currency businesses to home in the state of New Jersey, while ensuring that those businesses are appropriately monitored as they manage its citizens' money. It doesn't mean building a new licensing machine. It doesn't mean demanding compliance with a regime that was never intended to fit digital currencies. Instead, it means a well-thought-out combination of carrots and sticks that demand accountability while incentivizing new economic growth. For example, who might New Jersey regulate? Well, it makes sense. It makes sense to regulate custodians, not mere software companies. We should ensure that the people that we trust with our money are trustworthy, but permit mere software developers to innovate and build this ecosystem. What might we require of those people? Well, at this stage, I think registration is appropriate, not licensure. We should maintain accountability without excluding emerging businesses. We might want to require fingerprinting to make sure we know who's holding onto our money. I think we should absolutely consider requiring robust anti-money laundering policies, as is done in many other states. And we might require regular third-party solvency audits and cybersecurity audits. Ensure that these companies aren't operating a shady fractional reserve quasi-bank, and ensure that what happened in Mt. Gox, which was a combination of mismanagement and various other things, doesn't happen here in New Jersey. Now, those are some sticks. What about the carrots? Well, for one, creating a registration regime instead of a licensure regime means that New Jersey entrepreneurs don't have to ask permission to innovate. And that's a particularly attractive carrot in its own right. Alternatively, if New Jersey does adopt a full-blown licensing regime, it might consider granting reciprocity for businesses who already have a license in another state and home in New Jersey and employ New Jersey residents. We might consider tax breaks and some other financial incentives like tax credits or grants for digital currency businesses and ancillary service providers. We might even consider formally legalizing the use of digital currency in New Jersey's active casino and gaming economy. So in closing, New Jersey is faced today, in my belief, with a historic opportunity to become a hub of the new digital economy. Digital currency entrepreneurs are building this economy right now. And I ask that you give them a good reason to build it here in New Jersey. I have one that's embarrassingly marked up, but I'd be happy to...
If you could send it to Mark, I'd appreciate it, because
I would be glad to.
I think that you have some terrific ideas there.